Hello, everyone. Thank you for participating in today's webinar on PFAs and the Servicemembers Civil Relief Act. My name is Rachel Pinsker, and I'm a senior attorney here at the Pennsylvania Coalition Against Domestic Violence. Our presenter today is Christine Zellar Church, Associate Dean, Western Michigan University, Cooley School of Law.
Thanks, Rachel. So let's talk a little bit about what we want to accomplish today. The primary thing is to talk about the Servicemembers Civil Relief Act and how it applies to protection from abuse proceedings. The objectives for the training is to talk about that it does apply because prior to 2005, it probably didn't apply. There were a lot of changes that were made with the new Servicemembers Civil Relief Act. Then we're going to talk about two very, very separate things. One is default judgments against a service member in the context of a PFA. The second part is what happens when the service member requests a delay for 90 days under the SCRA, and what are the requirements that the service member has to meet, and what are the judge's responsibilities. Finally, we'll wrap this up talking about temporary orders and what can a judge do in a PFA to enter temporary orders when a service member requests a delay or a stay of proceedings for 90 days. So those are the things that we're going to be going over. I want to just outline a little bit first about the history and the purpose of the Servicemembers Civil Relief Act. Let me give you a little bit of background. I worked for 20 plus years outside of Fort Campbell, Kentucky in the legal services organization as a staff attorney. And I did a lot of work with domestic violence during that time. The 101st Airborne is located at Fort Campbell, Kentucky, and it is a rapid deployment force. Generally, judges who were around military installations were the only judges that had to concern themselves with the SCRA, or back then it was the Soldiers and Sailors Civil Relief Act. Since 9/11, we have had more National Guard and reservists who have been deployed. As a result, the issues of the SCRA are now something that every single court is concerned with and is faced with. Because this is federal in nature, sometimes that can make judges a bit nervous about making sure that they are complying with the federal rules. And so understanding a little bit about the history and the background of the SCRA and what it's for helps to look at any issues that are coming up in the context of the SCRA. I thought it was pretty interesting to note that when we were in Iraq, almost 40% of the armed forces were members of a local reserve or a National Guard unit. And recently, the Pentagon has signed orders to mobilize 2,100 Guard and Reserve troops to deploy to West Africa to fight the Ebola virus. Guard and Reserve that are deployed and are given active duty orders are all covered by the SCRA. And that makes it an issue that is very relevant to our state courts. So let's talk about this. The history of the SCRA says it is to provide for the national defense by protecting service members so they can devote their entire energy to the defense of the nation, and to provide for the temporary suspension of legal proceedings that may adversely affect their rights during their military service. This purpose section comes directly from the statute. The SCRA applies to any judicial or administrative proceeding commenced in any court or agency in any jurisdiction subject to this act. So now it is expansive compared to what it was before. The SCRA applies to PFA cases, dependency and abuse cases, adoption cases, things that it really didn't apply to in the past. The one thing that it does not apply to are criminal actions, but Pennsylvania law makes it very clear that PFAs are civil and not criminal actions. The SCRA applies to protection from abuse orders. State court judges are seeing more and more domestic violence situations that connect with service members. There have been numerous studies on intimate partner violence and PTSD and depression in veterans. The statistics are absolutely stunning. When you see some of these studies, they are showing us that approximately 81% of PTSD and depressed veterans engaged in at least one act of violence towards their partners in the last year. That's the conclusions of a very detailed study. And the reason that I'm bringing this up is because it's so important to know when you are working with cases of intimate partner violence and one of the parties is a military person, there is a distinct connection between deployment service and intimate partner violence. Many cases, what they're finding is that this violence was not there prior to the deployment, prior to the service. So it becomes a situation where we may be seeing more and more requests for PFAs in the state courts as a result of the military service. So, what's the first step? If the SCRA applies to PFAs, the petitioner then needs to file an affidavit prior to the issuance of any order. The affidavit has to be, is the defendant on active duty military service or not? For those of you that have worked with divorces, you're going to be very familiar with this kind of an affidavit. If the answer is no, that there is no connection with an active duty military member, then the case proceeds. But if the answer is yes, there is a connection between the defendant and the defendant is on active duty military service, then the court has responsibilities under Section 521 of the Servicemembers Civil Relief Act. The court must appoint an attorney to represent the defendant. That's the first step. The second then is that a default judgment cannot be entered against that service member until the attorney has been represented and the attorney has contacted the defendant. The service member may request a delay in the case once they are served or given copies of the PFA paperwork, because we all know sometimes defendants get copies of the papers before they are formally served. So they need to know what's going on. What if the petitioner doesn't know whether the defendant is on active duty or not? The petitioner might know that the defendant is a member of the Guard or the Reserve, but may not know whether or not there is an active duty order in place. This is a website that will let petitioners know and also court or court clerks know whether or not the defendant is listed as being on active duty service. So what you're seeing here is just sort of a screenshot from this website that tells you whether or not you can submit a single record request asking about a particular person. This is the information that is needed. So either social security number or date of birth. Most petitioners may not know a social security number, but typically will know the birth date. So that's something that can be used in order to make this determination. If the petitioner doesn't know either one, then that will make this website pretty much not something that you can use. Then we need last name, first name, middle name, active duty, status, date. That will be today's date when you're doing this, so that asking what is the status as of the date that you are submitting this request. So this is a great way to be able to figure out whether or not the defendant is on active duty service. In the question about what does the attorney do who is appointed under the SCRA, I have to tell you that the case law is all over the place. Unfortunately, the actual act itself doesn't give us much information about what are the responsibilities of this attorney and who pays the attorney for their time. We do know that the attorney has to notify the service member about the case. Based on what the judge's opinion is, the attorney may be required to represent the service member for some point of the case. One of the things that's very helpful is that the Judge Advocate General, the Army Lawyer's Guide, has some good parameters for the attorney and what the attorney does. What it says is that the attorney should contact the defendant and make sure that the defendant has actual notice about the lawsuit. That the attorney should advise the defendant about the protections of the SCRA. The attorney should advise the defendant about the possibility of the entry of a default judgment and the consequences of the judgment. And that if the defendant wishes, they can ask for a stay of proceedings to give them time to obtain counsel and prepare a defense on the merits of the case. Using what the Army lawyers are saying, the job of this attorney is really to provide notice to the defendant. And in some cases, when you're dealing with PFAs, this can actually be very, very helpful because the attorney who's representing or who is notifying is going to be contacting the service member maybe even before they are actually served with the PFA. And the notice goes out much sooner. And the protections of the PFA then will go into place. Now, the interesting thing is that most states do not include this kind of an affidavit in their state protection order forms. The PFA form doesn't have the affidavit. However, if you look at form number 10, which is the affidavit of non-military service in divorce cases, then you'll have everything that you need to be able to see the information necessary for compliance with the SCRA. When should you file this affidavit? The statute says it has to be filed before any orders are entered. Well, we know that when we are filing for a PFA, we're asking for an ex parte order to be issued immediately, providing some protection from abuse until a hearing can be scheduled. So the best practice would be to file that affidavit along with the petition so that it is filed before any orders are entered. So let me just sort of pose a question here. Let's say Rosa has filed for protection against her boyfriend who's on active duty with the United States Navy. Does the court have to provide the protections in the SCRA? By definition, it says boyfriend's on active duty in the United States Navy. That's going to be a yes because the defendant is on active duty service with the military. He is a member of the United States Armed Forces. The SCRA covers the Army, the Navy, the Air Force, the Marines, and the Coast Guards. And interestingly enough, although very seldom do we ever run across this, members of the National Health Service and members of NOAA, the weather people. They must be on active duty, meaning full-time. Look at this one. Here we've got Carolyn, who's filed a PFA against her husband, who's a member of the National Guard. Is the court required to provide the protections of the SCRA? Only if her husband is on active duty with the National Guard. The National Guard, if they are called to active duty for a military action, such as deployment, if they're on active duty for more than 30 days. So, for example, when we had a Superstorm Sandy and the National Guard was called to active duty because that's a national emergency. If it's just for a week to help stabilize and then return home, then the SCRA would not cover that person. But if it's more than 30 days deployment for a national emergency, they are covered by the SCRA and have to be given these protections. So here's another one. We've got a petitioner who has filed a protection order against her husband for an assault. He's on active duty with the Army, but he's currently in jail because of the assault. He's been there for 30 days. This would be pretrial, and the Army has begun paperwork to separate him from the military. Is he entitled to the protections of the SCRA when he is in jail? The good argument is no. There's case law that says he's not protected by the SCRA, and the reason for this is that it's designed to protect active duty soldiers who are committed to the service of their country, and this term is defined as full-time duty in the active military service of the United States. And the term includes training duty, annual training duty and attendance while in the active military service, but it does not include somebody who cannot participate in their military duties. So somebody who's AWOL is not going to be protected by the SCRA. Somebody who is in prison is not protected by the SCRA. And in fact, one of the cases actually comes out of Pennsylvania, which is a Court of Common Pleas case. This is from 1968, so it would have been Vietnam War era, means versus means. And in that case, we had somebody who was AWOL, and the court said absolutely not entitled to the protections. The SCRA, in that case, it would have been the prior Soldiers and Sailors Civil Protection Relief Act. So now we're going to move into Section 521. What we've done at this point is to give you kind of the basics. Does the SCRA apply to PFAs? Yes, it does. is who is covered by the SCRA, active duty, and then what are the responsibilities that the court has when an affidavit is filed that says the defendant is currently on active duty service, and that is to appoint an attorney. So that sets us all up for what happens next. In order to avoid a default judgment, Section 521 sets up exactly what the courts have to do. Of course, the first thing is appointing the attorney. And as we talked about before, this can be helpful in giving the defendant some notice that there are some orders in place, the ex parte orders that are in place. What if the judge doesn't? That's a question that gets asked a lot, because what if the judge just misses this in some ways and enters a final PFA order after the defendant has been served and after having notice does not appear? Then there is a technical violation of Section 521. What happens to the judge? What happens to the case? What happens to the protections that are in place? And this is kind of the good news, is that there really isn't any remedy for the soldier except, or sailor, except to ask to have the judgment set aside after a hearing. The important point to note here is that this means that the judgment is voidable, but it is not void. It can continue. It is in place if there was a violation, and at the violation hearing, the defendant brings up the fact that, well, this default judgment was entered. I didn't get an attorney appointed to me. Yes, I was served. Yes, I knew about it. Yes, I didn't attend, but, I am a service member and I should have these protections. Even then, he's going to be held accountable for the violation. It may be set aside or reopened as voidable after the fact, but it is still a valid order. And there are cases across the country ruling that the judgment is not void, but only voidable, subject to being vacated upon a proper showing that the service member was prejudiced by reason of his military service and that it would have affected his ability to make a defense. If the judge does not appoint an attorney, if a final order is entered without having an appearance by the defendant, it is still a good order. It is still an enforceable order. What if, though, the defendant is served and then wants to delay the proceedings, saying that he can't attend because of his military service? So the defendant can request a delay or a stay of proceedings for 90 days. That's under Section 522. So 521 defaults, 522 the stays. The requirements for Section 522 to get a stay of proceedings, it requires two separate things. One is a letter from the defendant explaining why his military duty requirements materially affect his ability to appear, and a date when he will be available to appear. So it can't just be, I'm deployed, I'm in Iraq, I can't be there. It's got to have a date when he's going to be back in the country and available to appear. So a letter from the defendant and a letter from his or her commander. The letter from the commander has to also explain why the service member's military duty requirements affect his ability to appear, and that the service member is not authorized for leave to be able to attend the matter at this time. Now, here's the most important thing, and this is a huge change from the prior law under the Soldiers and Sailors Civil Relief Act. If both documents are received by the court must issue a stay of proceedings for at least 90 days. Under the previous law, this was a discretionary question for the court. The court could say, I don't think that it really impacts his ability to defend. We could set up a video call and the service member could participate using video. I just don't think that there should be a stay. I think that we should go ahead and have a hearing. Under the current law, that discretion has been removed from the judges. So if both documents are received by the court has no choice. It must issue a stay of proceedings for a minimum of 90 days. However, it can extend the stay up to the time when whenever the defendant says that he will be available for a hearing, and that could be a year from now. So this is an important requirement, and in a PFA matter, it can delay some things and prevent the entrance of some temporary orders. Once the request for the stay has been properly filed, the court is not permitted to enter any order of any kind. That can create some issues. In PFA hearings, the judge will enter an ex parte order at the time the case is filed. The ex parte order typically provides for protections from abuse. It may provide some stability, trying to stabilize things for the family, and that ex parte order is fine because the request for the stay would always come after an ex parte order is issued. Typically, you're going to file for the PFA, an ex parte order is issued, and then the defendant is served. So an ex parte order is fine. The problem is that if you're trying to obtain stability for a victim of domestic violence, how do you do that without the ability to enter some temporary orders while the defendant is deployed? When I was working outside of Fort Campbell, a lot of times the judges would ask, why would you need a temporary order if he's deployed? He's in Iraq. He's not coming back to assault your client. The problem is that you never know when a military service member might obtain leave and be able to come back. And it's that surprise kind of showing up after being served with a PFA that can put a victim in danger. Having some orders in place that prohibit contact, prohibit further abuse, that's essential. That's the ex parte part. But then what do we do when we are trying to establish stability, not only protection from abuse, but things like support, temporary custody, and establishing some of these things. So these are some of the issues that we're going to explore now. If the judge enters a 90-day stay and the service member then asks for a second stay because he's not able to return, the second stay is discretionary. So for the judge to have the most power to control the proceedings, one of the things that a judge can really think about is the first stay limited to 90 days. Do what's mandatory, but do the minimum and do 90 days. Then, if the service member asks for a second stay, the judge can exercise discretion and say, I think that you're capable now of participating through video, through some of the technology that we have that will allow the entry of some temporary orders. Temporary custody and temporary support orders are really the big thing, and across the country this is the national conversation, because on one hand you have a service member who is asking for a stay and maybe does not want a temporary custody order instituted. You've got the federal law that says this stay is mandatory, but yet the judge wants to consider what is in the best interests of the child or the children, considering the situations of both parents. So let's look at an example of this. Let's say you've got a situation where Mike is in the military. He is active duty. He assaulted Kendra. They have a child together, Maddie. Right after the assault, Mike takes Maddie to his mother's house. That's 100 miles away. The same day as the assault, Kendra files for a PFA and asks for custody. Mike was served with that PFA, but then he deployed. 2 days after the assault, he goes to Afghanistan. What happens then? Mike comes in, he asks for a stay until he returns from Afghanistan. So here you've got the father who's in Afghanistan. He has unilaterally placed the child with his mother, probably given her a power of attorney, and the mother, Kendra, does not want to be without her daughter for an entire year. So what is the judge permitted to do in this situation? Can the court balance the interests of protecting the service member and the child's best interests so that both are being considered? Well, the answer to that is not fully defined. Pennsylvania hasn't faced this question in any of the research that I was looking at. There are states that have faced this question. Some states say yes, the court can look at the best interests of the child. The court is tasked with looking out for the best interests of the child and trying to evaluate what is in the best interests during the period of time that a parent is deployed. Other states, though, and it's pretty equally split, have said federal law preempts. When federal law says no order can be entered, that means no order can be entered. And in this case, a judge in Pennsylvania may have to say, I'm going to give you a stay for the 90 days that are mandatory because I don't have a choice in. And the child, I can't make any orders concerning the child until those 90 days are up. But then after 90 days, I can schedule the hearing. And if Mike requests a second stay, now that is discretionary with the court. It's a tough kind of call to make and difficult for judges because on the one hand, they're charged with providing safety, providing protection for the petitioner and the children, and taking into consideration all of the facts. Where is the child placed? What is going on in that placement? All of those issues. The judge really wants to be able to make those kinds of decisions and fulfill their mandate from the court. On the other hand, you also have judges who are very concerned about federal preemption, that federal law preempts state law, and that when federal law says you can't enter any kind of order of any kind once the stay is in place, they see that as being mandatory. So it does create some interesting questions. Thanks.
These are really timely topics that courts and court staff are dealing with, I'm sure, pretty frequently. And I am here, and I know, Christine, you've offered yourself up for assistance to individuals. And please, everyone, feel free to reach out with any questions or technical assistance issues that you may have. Thank you for participating in today's webinar on PFAs and the Servicemembers Civil Relief Act.